Okay, perfect. Hello, everyone. My name is Sandhya Taneja, and I'm honored to welcome you all to our event. We're so excited for our lineup this afternoon. We'll get started with an introduction and then launch into our question and answer session with our panelists. If any of our audience members have any questions, we encourage you to use the Q&A function at the bottom of your screen. And without further ado, it is my pleasure to turn it over to Barbara for our antitrust panel.
Good afternoon, everyone. So as you may know, the House Antitrust Subcommittee spent 6 hours last August questioning 4 very famous faces that had video Zoom before DC's House as subjects of a congressional hearing. The 4 famous CEOs, Sundar Pichai, Jeff Bezos, Tim Cook, and Mark Zuckerberg, fielded a slew of both right-wing and left-wing accusations detailing alleged instances of their company's misconduct. These accusations hardly came as a surprise. They had long since crept into the realm of public vision, growing bigger, bolder, and harder to ignore until they colored the once positive image we held of the innovative Silicon Valley darlings, who we at one point believed had a capacity to better the world. By that point of August 2020, the House Subcommittee had already been investigating these companies for longer than a year. Subcommittee members arrived at the hearing holding stacks of marked pages, pages meticulously chosen out of thousands upon thousands more, for a quote or a story that revealed a more sinister portrait of the CEOs testifying before them. After all, each of the 4 men had grown a platform so massive and so uniquely indispensable that the platform's characteristics themselves create avenues for that platform to consolidate its market power through unreasonably exclusionary means that could severely disadvantage its rivals. Most critically, dominant platforms act as both market participants and gatekeepers in select markets. Their gatekeeper role enables them to operate and structure the markets in which they also successfully compete against the third parties that depend on their own platform to reach their consumers. Dominant platforms also operate at several levels of a value chain and across products at a same level of a value chain. This degree of horizontal and vertical integration enables dominant platforms to foreclose competition in markets adjacent to those in which the platforms have significant market power. These features give tremendous incumbency advantages to dominant platforms, even in the absence of any anti-competitive conduct, and they create avenues for platforms to deliberately undertake anti-competitive practices. As we plainly see from the world around us, companies like Google, Amazon, Apple, and Facebook dominate today's digital sector. Their durable market power has garnered concerns from citizens, academics, politicians, and the public alike. These concerns, which come from both sides of the political aisle, stem from a shared opinion that current antitrust laws do not adequately address dominant platform conduct. However, they disagree vehemently about the objectives that antitrust laws ought to serve. Proposed solutions range from more aggressive enforcement of existing antitrust laws to a new enforcement mechanism specifically designed for digital platforms to a complete structural overhaul of the antitrust system. Our panel today looks closer at the proposed solutions for addressing the issues associated with dominant platform gatekeepers, including inter alia, potential approaches to regulating platform gatekeepers, and the scope of state and federal agencies' authority to prevent dominant platforms from engaging in anti-competitive practices. We are grateful to have 4 extremely distinguished panelists here with us today to help us accomplish this goal. First, we have Professor Eleanor Fox. She is the Walter J. Derenberg Professor of Trade Regulation at NYU School of Law. Before she joined NYU's faculty, Eleanor was a partner at Simpson Thacher in New York. She has also served as a member of the International Competition Policy Advisory Committee to the Attorney General of the DOJ from 1977 to 2000 under President Clinton, and as a commissioner on President Carter's National Commission for the Review of Antitrust Laws and Procedures from 1978 to 1979. She has advised numerous younger antitrust jurisdictions, received Lifetime Achievement Awards for her transformational impact in the field, and published multiple books on global competition law issues. Professor Daniel Sokol is a professor of law at the University of Florida Levin College of Law and a senior advisor at White & Case. He's also an affiliate faculty member at the University of Florida Warrington College of Business. Sokol is a non-government advisor to the International Competition Network for several working groups and an academic advisor to the U.S. Chamber's Antitrust Group. His research and teaching focuses on antitrust, corporate governance, compliance, innovation, and entrepreneurship. Cecilia Cheng is an attorney and Brill Fellow at the Antitrust Division and joined the division in 2009 through the Attorney General's Honors Program. Prior to joining the division,
2019.
2019, sorry about that. Prior to joining the division, Cecilia is a law clerk for the Honorable Douglas H. Ginsburg of the DC Circuit Court of Appeals. Before attending law school, she joined as a senior analyst at an economic consulting firm specializing in expert testimony for antitrust litigation. And last but not least, we have Emily Cotton. Emily has extensive experience conducting complex qualitative and quantitative analyses of data in both mergers and litigation matters. She has supported experts from leading universities and managed case teams in a broad range of industries on matters including antitrust, bankruptcy, class certification, intellectual property, securities, survey design, tax, and transfer pricing. Her recent casework has included assessment of competitive effects in major antitrust cases, analysis of Federal Commission's merger compliance, litigation related to the Lehman bankruptcy, managing independent evaluation of massive amounts of data in a major antitrust matter, and the determination of arm's length pricing in large U.S. transfer pricing matter. Thank you so much to all of our speakers for joining the antitrust panel of the Business and Finance Law Conference. By means of a quick introduction, my name is Barbara and I'm the moderator of this panel. We encourage you to submit any questions that might arise at any point during the event. My co-organizer, Sandhya, will be managing the audience questions, which we will address at the end of the hour. I would love for these questions to generate some sort of conversation, so please do respond to others' comments if you wish, and feel free to speak as many times as you'd like, and whenever you want to add anything to the conversation. Let's begin. So my first question is that the EU recently proposed a set of regulations specifically designed for dominant platforms to address its dominant platform problem. Should the US take a similar approach and treat dominant platforms differently than other firms? Is there something qualitatively special about these platforms or digital markets to warrant a unique set of rules that govern dominant platform behavior? Professor Sokol, I loved your article about antitrust and regulating big data, and I would love to start this one with you.
Thank you. So let me just say that my comments are my own, don't reflect any of my employers. I say what I think. I have tenure, I could do that, though frankly, I said what I thought even when I didn't have tenure. So let me just start in many ways in terms of thinking about the Digital Markets Act as one extreme approach. So I'm not saying that regulation is wrong, but what I am saying is that sometimes regulation can be incredibly blunt as an instrument. So on the one hand, the aim of the Digital Markets Act is to rein in the power of digital economy gatekeepers, right? But based on how they define gatekeepers, given the nature of how so many businesses are going through digital transformation, you can actually have a very wide definition of gatekeepers in Europe, in which case, what we know based on what can happen is that you might have overly broad regulation. So I'll actually suggest along these lines, what if you're going to have regulation, and I'd say outside of the United States, it's more or less a given. Inside the United States, not clear to me that we'll reach that point. But what would be the guiding principles that we'd want to see? So I'll give you 3 guiding principles, because it turns out most students start tuning out after 3. By the way, it's not just students. So number 1, preserve business model innovation. Platforms represent a new and evolving way of organizing economic activity and coordinating independent multiple actors to expand value propositions to customers. Since there's some business school students in the audience, I use that terminology. In antitrust, we would say efficiencies. So what we don't want to do is ban certain critical levers of the platform business model through some kind of overly restrictive regulation for all firms, mandating specific design choices, because that would constrain particular business opportunities. Instead, the focus should be on particularly problematic activities by platforms that are competition problems, essentially. Whether or not competition law, we'll leave aside for a moment, but it's certainly competition problems. And here I'm thinking of specific anti-competitive practices that create structural barriers to competition between platform ecosystems. In the second part, I'd say focus on why these platform ecosystems are competitive. Don't focus on who's winning. So basically, that might be making some amount of data more portable, allowing customers to use it on more than one platform, rather than try to say partition platforms through breakup, or to dictate which businesses on a given platform a business should or shouldn't be in. Third, I'd say foster market contestability in adjacent segments. Much of the innovation that we see is not people creating the next exactly the same of fill in the blank platform. It's actually doing something somewhat different. So you want to actually have more differentiation, because the disruptor that successfully challenges incumbents is going to be providing, as I said, something different, and there are clear benefits to that. So let me, with those 3 points, let me give an example simply on that last one. So it turns out, dating is a highly differentiated market. So I'm told, I haven't actually been on a date with someone other than my wife since January of 2002. But my understanding from my current students is that there are a number of different dating apps, all of which have different business models. Barriers to entry are low, multi-homing is significant, and you don't compete with existing dating platforms by doing exactly the same. Tinder competed by doing something that I think people have been doing for a long time, some kind of binary swipe left, swipe right. We just didn't call it that. Bumble's great because the woman, it turns out, is the one who asks out the man, because it turns out on a lot of dating apps, men will swipe whichever direction it is to get potential dates all the time, totally no quality control, whereas women are actually much more careful. So again, each of these shouldn't have succeeded, right? If we believe that platforms, network effects are durable, this shouldn't have happened. But instead, we saw platform competition across platforms in adjacent markets, largely with somewhat different business models. And that's what we would like to see more of.
And Emily, I would also really love your take on this too.
Sure. So again, as Danny said, my opinions are entirely my own. They are not the opinions of Analysis Group or any of our clients. But I also tend to speak fairly freely. So I'll just say I'm sadly still on all of the dating apps that Danny is talking about. And I'll agree there are a lot of different adjacent platforms and markets happening there. As an economist, I kind of come at antitrust and come at all of these concepts such as regulations from some real economic fundamentals. And so I think you need to think about what incentives the regulations that are being proposed in the EU and other countries are kind of setting up, and how companies are going to respond to those incentives, right? We don't live in a kind of static world where nothing changes and you can say, hey, here's a regulation and this is how it's going to affect commerce. Everything, as Danny pointed out, is constantly innovating and changing. And so I think in thinking about these EU regulations, you need to think really, really carefully about who they are targeting and whether who they are targeting is going to now be at some form of a disadvantage and whether that's good for consumers. And kind of how that targeting and the set of incentives that are being constructed is going to, benefit or harm consumers in the future, is going to disadvantage or advantage innovation. And I think that is something that, at least in my experience, regulators outside the US and acting bodies outside the US take in kind of a different way than the US does. And I think in the US, we have a flexible set of antitrust tools that has done a reasonably good job at kind of working through these problems. And you want to kind of think through, who's been in this situation in the past, how have those kinds of experiments played out, and who's likely to be the next wave of companies, potentially once the current set of dominant platforms are gone. And so those are kind of the ways I would approach and think about the issue of the EU regulation.
Thank you so much. And Eleanor, are you able to give us a take on this one too?
Oh, sure. Of course, this goes right to the heart of what we are talking about. So Barbara, I understood your questions to be asking essentially two questions. One, you could say, do we want to be more like the EU and their regulation? And two, is there a case to be made for separating out big tech? Should we be thinking about what to do about big tech, or should we be thinking about rules in general? So I want to address both of those, and actually our colleagues addressed them and parts of them. So I would address the question, why are we talking about big tech? Why aren't we just talking about antitrust principles and rules in general? It seems to me that there is something very special about the big tech phenomenon. And I often use the acronym GAFA. That's the 4 main platforms, but there are a few more, Google, Apple, Facebook, and Amazon. There are a few more, but I might throw out the word GAFA. There's something very unique about the GAFA that arose within the last decade and a little more. I mean, you can say 2 decades, but really with the vengeance in the last decade, and maybe even with a bigger vengeance now, where with the pandemic, we've seen so much commerce move over from brick and mortar to digital. And digital is really a big thing. And digital, we see, has become, I'll use the word dominated. My colleagues might want to use another word, but we see these 4 or 5 or 6 huge companies, bigger than most nations, that have gotten huge shares of certain segments of commerce through network effects and focusing on data, and each one being very powerful in its own niche and having effects which we're still exploring. And it's not just the antitrust effects, obviously, but effects that seemed quite new in terms of, some would say, there's sociology, there's psychology. There are those who claim these companies have a kind of mind control, as well as consumer protection problems, as well as data problems and privacy problems, and certainly some antitrust problems. I think we do see some new forms of power. And when on the antitrust side, when we try to apply antitrust rules to them, we find that the antitrust rules are formulated for more like smokestack industries and not digital industries, because the antitrust rules were formulated at a time and when we could think more, and for antitrust even solely, about price and output. And the behaviors of the big tech firms that are up for challenge are really not about output and often not about price. So there is now, as you mentioned, Barbara, the hearings, the House hearings, which documented in hundreds of pages behavior, incidents that many people think are abuses by the big tech, even though they've done great things for us too, and we shouldn't forget that. But given the power they have, they brought a lot of new services to people, but they also have done a lot of, and do a lot of practices that are considered abusive. And people can debate whether they are antitrust problems or not. I think there is a sentiment that these abuses ought to be controlled. There are abuses that relate to gatekeepers who are squeezing out and sabotaging rivals on their platform. There are conducts that the companies are making it less easy to interoperate or move your data to another system. And they're both exclusionary and exploitative. They're very well documented. We have all of these facts now. And if these certain of the practices should be prohibited, maybe there ought to be a set of rules and principles that are devoted to what we see happening and maybe isn't easily addressed by our current antitrust laws. I probably shouldn't talk about EU there or yet, because I've already spoken too much, but maybe later, because I would like to say something in the course of this about what Europe has done, and if something should be done, they're way ahead of us. If nothing should be done, they're just too regulatory, but we should really be talking about that too.
Excellent. Yeah, I think when I ask a few more specific questions about regulation, definitely the EU will come up again. And Cecilia, I would also love your take on this, please. Thank you.
Great. Well, I want to first begin by thanking you, Barbara, Sandhya, and the other organizers for inviting me. I'm really grateful to be on this panel and what I think will be a really fun discussion already with many whose academic writing I read in law school and whose work really helps to continue to push our understanding of these digital markets and competition. And I too have to emphasize that although I'm an attorney at the Antitrust Division, I'm speaking only of my own views, and nothing I say today is meant to represent the views of the division. So with that, I want to focus on your last question, Barbara, and it's something that Professor Fox drew out, which is, is there something qualitatively special about platforms and digital markets to warrant, a unique set of rules or a new rule book or a way of thinking? And the heart of the issue, I think, is not really whether there are unique features in tech markets, but rather, are these attributes sufficiently different to warrant a new rule book or a sectoral regulator, as we've seen sort of emerging more in the talks in the EU. And it's, I think, maybe a line drawing exercise that's quite difficult. But I want to say, this isn't really the first time that we'd, call an industry out for sectoral regulation. And I think it's pretty, it's commonly acknowledged that sort of all market sectors are unique in some way. And we approach, the government approaches certain sectors differently precisely because of the unique economic factors of each market. So this might not necessarily be competition issues, but other types of market failures or distortion in the industry. So for example, if there's intense informational asymmetry in the financial markets, we regulate that differently via the SEC, or there's a lot of moral hazard or other types of failures that we want to correct in the healthcare market, we have regulation in the healthcare market to address those. So I think, in terms of whether there's a need for a sectoral regulator, I think it's hard to account for this conversation without looking broadly outside of the antitrust sector, because sometimes a lot of the concerns that, maybe that you had been talking about, Barbara, are not necessarily directly competition concerns. Sometimes they implicate a lot of other types of law and legal regimes that we want to think about too. And so we don't see, for example, we have the SEC, but we don't also see sort of a competition for financial markets type regulator or enforcement agency. And I think that's in part due to the fact that the antitrust agencies do try to account for the unique economic qualities of each market when they make their analysis. So when it comes to big tech, some of the unique features of the market have been, discussed by a lot of different commentators and also by the other panelists here. And of those, I was planning to highlight two that I think have really interesting implications for thinking about this. The first is sort of conceptualizing of sources of competition more broadly. This is something that Professor Sokol had first brought up, with the Tinder example. And I think that's a really good one of how we think about differentiated services. When I took Econ 101, whenever you learn about perfect competition and what perfect competition looks like, it's a fragmented market. You have 10 producers and they're all really fighting to big hats, or like one widget that's sort of similar to all the other widgets that everyone else is making. And in the real world, which is not Econ 101, the perfect competition, or as close to perfect competition as we can get in the tech sector, is not going to be everyone racing to make hats. It's going to be, Facebook supplanting MySpace, TikTok supplanting maybe everything else on the internet. And so I think that type of competition and what our view of perfect competition looks like in this market is a little bit different. And it might be more sequential, and competition can help grease the wheels of that sequential movement to try and make things move faster, have that turnover move faster, is one way to think about it. And so that's the first kind of feature that I think we would want to account for and think about. And then the second feature that commentators have identified is that there's often, zero price in this market and informational asymmetry as a result. And here I'm not talking, about all of the dominant platforms that we commonly think about, but specifically, I would say maybe Facebook and Google, or those that have advertising-based business models, is probably where that concern is most salient. And, I suspect there's going to be a lot of ongoing discussion throughout the rest of this panel about this question and in the broader conversation. But I think there are some interesting questions posed by, how consumers aren't really exchanging money, but instead privacy and their data for use of these platforms. And in some ways, this is a good thing because zero prices are frictionless and it increases access for a lot of people who wouldn't otherwise be able to afford this, but I think also it poses some interesting questions. So like a lot of libertarians like to cite Hayek, and in the 1940s, Hayek wrote a paper called The Use of Knowledge in Society, where he talks about the communicative value of price, which is that prices allow markets to efficiently allocate resources because a manager doesn't need to know why aluminum prices rose, only that they rose by a certain amount. So she allocates her resources as necessary. And these little decisions, I guess, trickle up to the broader economy. And then that allows, prices allow sort of the invisible hand to work. And now without this communicative value in prices, where we have, privacy and data, I think it does pose some questions and challenges and can lead to different types of information externalities. And so I think, a lot of economists have looked into this question and led to, I think some people have called for whether new tools like privacy laws or other ways to educate consumers can supplement the efforts of antitrust law here.
Excellent. Thank you all so much. So I guess a preliminary question that we should ask before we think about regulations is who's going to issue them? Both the federal antitrust agencies consider themselves enforcers and not regulators. Should this mentality be rethought? Commissioner Chopra has argued for the FTC to use their rulemaking authority in Section 5 of the FTC Act to promulgate new regulations. Is it more appropriate for the agencies to issue regulations, or should the question of reforming antitrust law be left to the legislature? Cecilia, for this one, I would love to start with you, especially since you were a law clerk and saw these cases play out. I think your perspective would be invaluable on this one.
Sure. So, the debate on this has been really lively on legal and policy grounds, and there's been a lot of articles, including Rohit Chopra's article and on FTC rulemaking, that offer sort of legal and statutory and legislative, history type arguments of why the FTC would be on sound legal ground. I won't repeat them here, but I will point out that actually in the Supreme Court's National Petroleum case from 1973, which confirmed the FTC's general power to engage in substantive rulemaking, the appellees there who opposed this rulemaking power actually argued that unlike these other agencies making rules, the FTC was different because it's a prosecuting agency and not a regulatory agency. And the Supreme Court actually rejected this argument there. And its primary reason, among others, is that there might not ultimately be a functional difference in rulemaking versus adjudication. And this is something I know a lot of administrative scholars have spilled ink about, probably too much ink than I can bear to imagine. But they talk about how the pervasiveness of the antitrust laws, and I'll quote here, what they said, which is that the FTC's duty to prevent unfair methods of competition and unfair or deceptive acts or practices is just as potentially pervasive in the sense of affecting commercial practices as the regulatory schemes of agencies, unquote. And so I think that's sort of an interesting opinion there, and you can take a lot from it about what exactly, what is the line between regulation and enforcement, and maybe use it as a basis for thinking that the FTC would be on sound ground. But in general, I think there's a lot of regulatory elements in enforcement regimes. Back in the 1990s, Thomas Cowper had written an article saying that the DOJ itself articulates certain policies through guidelines, right? And screening procedures, through business review letters. These can all help bring notice and certainty to the business community without being binding rules. So these guidelines, aren't binding unless the specific rules are adopted by the court. And so I won't say any more on this, but I'll just point out it's possible the DOJ is maybe situated differently from the FTC when it comes to promulgating rules, but I think there's a lot of good discussion out there about it.
Excellent. And Professor Sokol, I saw you nodding, so I would love your take on this one.
So long as we have two different antitrust agencies with two different functions, it creates problems if you're in front of one agency but not the other. Now, some of that is natural by statute. So if I have a financial services type situation, I'm going to go in front of, or airlines, I'm going to go in front of DOJ. That's part of the package. But if you could be in front of both of the agencies and there's very different treatment across the two, this becomes troubling because one of two things happens. It's not a stable equilibrium, essentially. So we either get a single antitrust authority, maybe that's good, maybe that's bad. Or the alternative, which is to say I'm agnostic, maybe some others have their own view on this. The other alternative is that you have disparate rules depending on which agency you're in front of. As a rule of law matter, that to me is a bit problematic. What I would simply add, again, I am not an administrative law scholar, but when I talk to my friends in this area, the other part of it that you talked about is rulemaking versus legislation. So I want to focus on that distinction for a moment. So when I talk to the administrative law scholars, they say, you know, changing rules, particularly for legislative overrides, actually it does not have a happy history. It doesn't really work. If you want to change a single case, sure. If you want to change an entire way cases are viewed, like, and by that I mean like there's a tax decision on a particular case and then you close that loophole. But if you want to change an entire sort of stream of law, let's say employment law, the empirical work suggests these kinds of legislative overrides don't work. So I wonder if actually we're focusing on the wrong institution, because the institution I think that matters the most is the judiciary. This is essentially the closest we have to common law outside of a traditional common law field, but don't take my word for it, take the Supreme Court's word for it. And I don't just mean recently, which it was, but I say that they've actually literally talked about the common law nature of antitrust law since the 1930s. And Appalachian Coal actually being the first case to my knowledge where they talk about antitrust as a form of federal common law. And so I wonder if by focusing on rulemaking, we don't put the emphasis where it should be. How do we actually change the way courts think? Sometimes courts get it right, sometimes courts don't. And I think we're all concerned about where courts get it wrong. Because either they don't quite understand the economics really isn't well settled, and it creates a certain path dependence, or alternatively, there are areas where either the law is too expansive or not expansive enough to reach certain kind of conduct. And in my mind, focusing on the regulatory aspect, which I don't think is stable, and I don't think we necessarily get to the right outcome, takes us away from the important question. How do we change what's going on in the courts?
Yes, Eleanor, go ahead. Thank you.
Okay, so I'll jump in. Very interesting conversation. I'm going to mostly go back to where Cecilia left us and maybe set the stage even a little differently. Because of the way I see the problem with the big tech. I normally would choose antitrust instead of regulation. I normally wouldn't even think about FTC regulation of big tech behavior. But where are we now in terms of our antitrust law? And is our antitrust common law interpretations of the Sherman Act fit for controlling big tech? And so here I want to express a point of view, which maybe some of you share and some of you don't, that our development in the common law way of Section 2 of the Sherman Act, which is the monopolization section, has been towards a very conservative point of view, mostly giving a lot of weight to the incumbents and what they do and presumptions that what they do is usually good and usually good for consumers, and making it very, very hard for a plaintiff, including the federal agencies, to win the antitrust cases. They've reset the stage from where and how we think about what is anti-competitive action, and even what is necessary preliminarily in terms of the proof of the market power. And because of that, which I view as a very conservative formulation of antitrust, much more conservative than most of the rest of the world, it's very hard to win cases where we say or we think Google has engaged in restrictive practices, Facebook has engaged in restrictive practices. Those cases, and the federal government agencies have brought them now, they might go through the courts for 10 years, and it might in the end, going up to the Supreme Court might say, well, Google really didn't have monopoly power because the competition really was a click away, and look at whatever becomes the circumstances of the moment today, 10 years from now, and or there's no proof of output limitation, so no violation. And then where are we? Because of the various practices that have been documented as abuses by the big tech firms, I think it's necessary to do something sooner than what will happen in the federal courts. And I also think it's necessary to do something that will reset the stage of what is illegal, because otherwise these firms will keep doing the practices they're doing. So I see the FTC as a reasonably good body to handle this problem of maybe of a few rules with rights of they're not bright line rules, but rights of argumentation that this is really good for competition, but rules that will pinpoint certain conduct and say, no, you can't do this. It might be even not just strictly antitrust. It might be antitrust in certain unfair competition. It might be antitrust in certain taking away data is appropriating data by the big firms. It might not be an antitrust problem, but the FTC having both having jurisdiction both on unfairness and antitrust could meld these grounds of antitrust plus unfair competition, antitrust plus consumer protection, plus some data protection, and make some few rules that would rein in big tech, even while the cases are wending their long way through the courts. Then, of course, there's a question of Congress we'll come to later, because again, I've said too much now.
Yes, Emily, thank you so much. I'm very interested to hear your perspective on this, especially as an economist with regard to the expertise required to actually promulgate regulations.
So I think in terms of kind of legal, legal forums and where this should happen and kind of where the dynamic is between the FTC, legislation, regulation, as an economist, I don't think I have much to offer here. All of the kind of legal scholars that we've got on the panel have a lot more experience and background there. But I do think I'll have more to say kind of about how the economics of these platforms play out and kind of what those incentives are, which I think we'll get to in some of the later questions.
All right, excellent. And I think this one is very EU based. So I think this one will go to Eleanor, and it is about ex-ante regulations. So ex-ante regulations could target behavior like self-preferencing, reducing interoperability, squeezing, and punishing rivals that could reduce market dynamism and eventually threaten consumer welfare. Ex-ante regulations do appear in the new EU Digital Act on Digital Platforms and have been frequently cited as potential solutions for the dominant platform problem. What are some advantages and disadvantages of regulating anti-competitive conduct ex-ante? Should ex-ante regulations target barriers to entry from increased switching costs, or should they be broadened to address larger classes of conduct inherent in digital markets?
Oh, okay, thank you, Barbara. So this does follow from our conversation. And so what are, let's say, what are the costs of regulation? And here I'd go back to some that Danny said. Regulation can be too regulatory. And incidentally, if we did have a regulator, a new regulatory agency for big tech, that would create these problems to begin with, because then you would have a whole huge staff of people who want to regulate and probably would be regulating more than is good for consumers and efficient competitors trying to reach the consumers. Even simple rules that are not a huge new regulator can do that. They can be overbroad. That's a big downside. However, I do think there's a big upside. I do think that we ought to be watching EU more than we are, because the European Union competition and a digital economy, it's not just antitrust. It's e.g. Directorate General Connect and Directorate General for the Internal Market, as well as the Directorate General for Competition, trying to create a single digital market that is fair and efficient. And they have proposed two different acts. One of those acts, the Digital Markets Act, proposes a set of ex-ante rules. The ex-ante rules proposed are perhaps too regulatory because they have a black list and a gray list and also a white list. You can imagine black is don't do it. Gray is there's a presumption that this kind of conduct is anti-competitive and illegal or simply illegal, but can be justified. And then the white list of what you can do. That's usually or could be a straitjacket, but the way they've written the rules, they want to experiment with a short blacklist with some flexibility of getting more information and deciding if conduct doesn't belong there. They have a lot of built-in abilities of the digital platforms to show that this is really competition, not harm to competition. And in addition, this hasn't been adopted yet. There's a lot of conversation going on. So there's been so much thought about what are the bad practices. So I think if we're looking for a universe of possible bad practices, we could start there, shoot some down and boost some up. And are they really bad? Are they really harmful to competition? There's one big point that we didn't talk about yet today that we really have to talk about, which is the goals of antitrust. To the extent we're talking about antitrust, to what extent would we be concerned about fair and free access for competitors on a platform as opposed to consumer results? So the EU is concerned about both. I know there are many people in the United States who would like to keep that separate. There are other people in the United States that we're not doing enough to keep markets clear and open for entrepreneurs. But that's a goals question. So I think it's very important to look at what EU has done and build from there and look at all the comments and the writings and the thought that has gone into what's bothering us, what's wrong, what should be controlled, how should it be controlled, should burdens be shifted?
Absolutely. The EU is definitely one of the stronger antitrust laws right now. And Emily, for this question, I'm really wondering about your take on the sorts of different types of ex-ante regulations. Should they target switching costs, barriers to entry, and from an economist point of view, which one would be the most effective in terms of reducing any competitive risks of dominant platform conduct?
Sure. So I think, and this draws on some things that I think both Danny and Eleanor said in response to the first question. And actually, Cecilia brought up some of these issues as well. It's important that we remember that these businesses are platforms. And so there's some kind of fundamental things about platform economics that we haven't talked about yet that I think complicate some of these issues. So if we're thinking about, for example, barriers to entry or some rules within a platform, there are lots of ways you could think about those rules as being kind of anti-competitive, right? Rules keep you from porting your data from one place to another or limit interoperability. But the flip side of those kinds of rules is that they kind of are fundamental to what in platform economics we call coring. And so coring on a platform is kind of how you ensure a consistent experience and how you balance the two sides of a platform. So let's say, for example, we're talking about, let's go back to like the fundamental kind of platform economics example, which is a singles bar, right? You want to entice both men and women, assuming this is a straight singles bar, to come to your bar and meet each other. And so you kind of have to offer different prices to each side of the network. And you need to offer a set of rules of engagement so people kind of know what they're buying into or what product they're getting. And so in setting up these regulations, it's really important that we don't inadvertently strip the platforms of their value. And so I think you have to think about not only how do we ensure that there's competition, but as we talked about in the first question, kind of where is that competition coming from? Is it coming from an identical platform? Is it coming from an adjacent platform? Is it coming from a kind of single-sided market that's on one side of that platform? So where does the competition come from? What are you really restricting? And does kind of some regulation that you may enact actually take away from the value of the platform and inadvertently harm consumers, or just make the platform's product less desirable and therefore kind of kill the platform. And then I think another thing that I believe Cecilia mentioned earlier is you have to think about this idea in economics of kind of leapfrogging. And so again, you know, in doing these ex-ante regulations is really, really hard, right? You have to target at something. This is exactly what Eleanor was talking about, is you have to think about what your goals are. And so I'm not saying that ex-ante regulation is right or wrong, but I'm saying there's a really long list of questions we have to think through and kind of make sure that we get right. And there are a lot of really, really tricky questions. And so from an economics point of view, I would want to make sure that we're kind of taking into account the fact that this is a platform business, that there have been many platforms over time that people thought were dominant platforms, right? There are times when we thought Apple was a foregone conclusion and totally out of any sort of relevant business, and now they're back. There have been various times when Microsoft was the dominant platform, or AOL, right? Who would have thought that WhatsApp and Facebook and kind of iMessage would be the way we were messaging, you know, 20 years ago when AIM was the biggest messaging app in the business. And so I think you have to be very careful at kind of what you're directing your regulations at and what business practices you're encouraging, how you're allowing there to still be value within the platforms, and kind of how all of those things interact. So ex-ante regulation feels very, very difficult to me, whereas ex post, you're able to see what behaviors have occurred and address those actual behaviors. And so that's kind of how I would think about all of this as an economist, but I know that's more questions than answers, which is kind of where this all continually leads me.
And Cecilia, I would love to go to you now for this one.
Sure. You know, I'll add to what Emily said, and maybe in thinking about the incentives of how, you know, how these rules will affect companies, I think one thing to consider is that, you know, rules and regulations might actually have the effect of, you know, insulating some of the incumbents that are out there, because complying with these rules and regulations can be expensive. So I think it's important in crafting these rules and regulations that we're nuanced and in being sort of attentive to the effect on competition and smaller competitors as well, including competitors that are just getting their footing. Of course, I think it's possible to write rules so that there are carve-outs. You know, if you're below a certain, you know, market size or a certain daily active user, certain rules might not apply to you. But, you know, this might be an empirical question too on the ultimate effects of it. And these sort of downsides that have been identified need to be balanced sort of with some of the advantages of rulemaking, which is that, you know, it's much faster. Enforcement, I think we would all agree, takes a longer time. I think the Microsoft case took 13 years from when the complaint was filed to the end of the remedy proceedings. And I think, you know, rules give more notice to the business community, and there's wider public participation. You're not making sort of laws at the margin of saying, you know, in this edge case where there's this breakdown, how should we think about this issue? But instead having sort of more transparency and having everybody weigh in who are involved in not only, you know, smaller businesses and participants in the market, but also consumer groups and different sort of stakeholders in that market. Regardless, though, I think, you know, if we were in a rulemaking world and on balance we decided that was better, I think, as Professor Sokol said, we need to be precise about the harm rather than maybe thinking only about the target companies that we want to sort of catch in this net. And I think, you know, as far as substantive areas, targeting sort of these switching costs and greasing the wheels of this type of competition, I think is probably, I think, a place that is worth focusing on and is interesting to focus on. I think that there's a lot of talk about interoperability and data portability so that there's not as much of a lock-in effect. And those who advocate for these rules say that providing these types of solutions via rule can make up for the lack of duty to deal in American antitrust law. Right now, you don't have a duty to help your competitors in current antitrust law, but it's possible that this can, you know, as Professor Fox said, you know, alter our way of thinking of, you know, what exactly and what do platforms owe the people who are on them, and what do they owe to others who rely on them in some way, even if they're not directly on the platform. And another idea I think is, and something I think that the EU has tried to address, or one of the questions that they're thinking about, is sort of addressing, killer acquisitions when companies buy up sort of nascent competitors with an exclusionary purpose. So, sometimes acquisitions can be defensive. You don't want a little firm to grow up to a big one and challenge you, and you don't want your competitors to buy the little firm and then challenge you. So I think there's sort of an economic value in the firm itself, and then a separate economic value from the exclusion of the firm. And maybe there's some way to think about that question where you compare the relative percentage of, how much is this acquisition from the firm and how much is the acquisition from the exclusion. And so I think this is also an area where, because no company or enforcer has perfect, 2020 forward-looking vision into the future competitive landscape, this might be an area where that's worth exploring further for rules and regulations. And Herbert Hovenkamp's recent paper on platforms actually offers one way to think about this. And he actually suggested sort of requiring, as part of these types of nascent acquisitions, that the combined firm be required to license IP non-exclusively. So even if these transactions were allowed, that at least the innovation might not be lost. And I think that's an interesting idea. But regardless, I think also that, maybe building sunset periods into potential future rules could be an interesting possibility and mitigate some of these risks. I assume these rules, aren't going to be in the books forever. If we were to create rules, they're not just going to, carry on forevermore. And I think there are ways to see the results of these regulations quickly and then dispense with them if they backfire.
Thank you so much. And Professor Sokol, I know you've written about pro-competitive and anti-competitive effects of big data. I think that's something that's very interesting about data markets, is that the network effects that kind of form the industry act as barriers to entry themselves. And that kind of, to me, seems like a complication for issuing any ex-ante regulations that target certain barriers to entry. So I would love to know your take on this one.
So let me take a step back. There's some data where we can easily get the data from other sources, either public or from data brokers or what have you. In those kinds of settings, frankly, there is a secondary market that allows us to work this out. A lot of times people focus on mobile ad tech. That's the area I actually worry the least about. I'll actually give you the focus of where I worry the most about. It is tech, but it's not quote unquote big tech. So again, going to what is a platform, what is a gatekeeper? I worry about industrial type tech platforms where in fact they are clearly the monopolist, where there's nothing else like it. I worry in some parts of health where there's a monopoly on the specific type of data that you can't replicate through commercial data. I worry about areas essentially that are unsexy. So if we think of big tech as being sexy companies, and for those of you who are just learning about antitrust, the fact that this is what we think of as sexy tells you exactly how nerdy we all are. But I actually want to focus on the unsexy part, because that's where you have a lot of the more significant problems, where I used to think, well, we don't have really any data monopolies. After spending a semester in the College of Engineering, I no longer think that. What's clear to me is we do have it in terms of where data is being generated. It's just not where people have been fixated. And if what we focus on is the kind of conduct, then a lot of times it's not the consumer facing part, it's upstream. And there, we're not doing the job we need to. And if we look also, so let me also be clear, the idea of a mechanism of a killer acquisition, which was a biotech concept. Well, but if we could take something in tech-based, non-biotech, but more app-based, it's different. It's more killer integration more often than killer acquisition. It is a bit different, and it's not even IP focused. I'll get to the IP part in a second. I'd say, if we accept that mechanism that's happening, I'm actually more concerned with those parts of the economy that we're not really focusing on, where there's still a lot of innovation, but just doesn't get the attention. So, we might even see some of that in ag tech, and we don't do that kind of focus. So that's number one. Number two, I want to take Professor Hovenkamp's IP licensing in a different direction. I was similarly concerned roughly a decade ago when we saw a number of acquisitions being done for IP portfolios, particularly with the idea of basically shutting people out of standard essential patents or what were commercially essential patents. And if we look from that standpoint, I understand where Professor Hovenkamp is coming from. This was an area where it's not clear to me, forgive me, that the Department of Justice made the right call. Cecilia, was before your time, so it's okay. But I'd also say, so I'd say we do have other areas where we worry about, like, why is it, so if we take Cecilia's framework of what part of the deal is for anti-competitive effect versus underlying value, that's not a bad framework. I mean, to the extent that we can actually quantify that's exactly the sorts of questions we should be asking. But now there was another aspect to it of what about in this regulatory setting? And here I'd say antitrust's sort of broader oversight hasn't been a happy one. And Eleanor, you remember when the Tunney Act was passed as a result of Nixon and ITT to try to depoliticize antitrust. I would say, and I don't know if you agree, the experience with the Tunney Act to try to get that kind of stakeholder involvement hasn't been quite the success that I think that that Congress anticipated at the time. And I'll just leave it at that because I want to open up for Eleanor, because I bet you didn't see a Tunney Act question coming up.
Oh, so you want me to respond on Tunney Act, and I'll just give you a short answer on Tunney Act. It's a little diversion. So yeah, there was a really bad incident in our antitrust past history where President Nixon had non-transparently gotten the withdrawal of 3 really important actions that were going to go up to the Supreme Court. And so in other words, it was a sweetheart deal settlement, and the public was very enraged, and it involved politics and payoffs. And so I thought the Tunney Act was very appropriate because it was intended to air settlements. But however, as happens so often, processes are co-opted, and now any action that the United States brings and settles must get Tunney Act approval by the judge. It's usually a rubber stamp and doesn't mean anything today. And I'm not sure how better regulation would have prevented that. Good purpose and co-opted. So Barbara, did you want more discussion on killer acquisitions at this point? I wasn't sure whether that was on the table at this point or later.
I think that this is a great place to start talking about killer acquisitions. I think that after that, I will ask one more question, and then I will hand it over to Sonia. If that sounds good to everyone.
Right.
All right, excellent.
Oh, so did you want me to start on killer acquisitions?
Oh, yes, please. Thank you.
So killer acquisitions has become a big part of the scene and talking about big tech and what goes wrong. And Cecilia mentioned this. Killer acquisitions, actually, it's a normative word, a disapproving word, and the companies themselves deny that the acquisitions they make are killer acquisitions. So, of course, the Facebook incident is one of the most interesting because Facebook bought WhatsApp and Instagram when each of them was just a little startup. And the federal government looked at it. In fact, it was looked at all over the world and passed as not anti-competitive all over the world. But it turns out that Facebook had acquired also a software to help it detect who was going to be the big challengers. And with all of Facebook's data and this application Onevo, it was actually able to make a prediction it believed in. And it was buy up all of the startups that were pegged to be potential challengers to it. And so now we're at a stage, these acquisitions have happened. Some of them got killed off. Some of them got compromised, and some of them, like Facebook and WhatsApp, got repurposed to be very complementary to Facebook. And now the federal government is suing FTC, Action Against Facebook, looking for it to perhaps divest of WhatsApp and Instagram, and states of the United States have also brought actions along the same line. So these are really interesting questions because the acquisition at the time it was made was not obvious to the outsider that it would be anti-competitive because this was just a small startup. And how would the enforcer like the FTC predict that if Facebook acquires Instagram or WhatsApp, it was taking competition off the market? That's what it would have to predict. The question is what to do now. When some people think they have found out, yes, indeed, it is anti-competitive and it was a way for Facebook to grow in an anti-competitive and monopolistic way. If you didn't buy into what I just said, it's not an interesting problem. So I'm going to assume what I just said, that people looking at it now say, yeah, this is really anti-competitive and allowed Facebook to become a more entrenched monopoly. And now we do believe, that's a very soft word, that if Facebook or WhatsApp were left to grow on its own or were acquired by someone else, it really would have been the good competitor and challenger of Facebook. I said we're going to assume that, but that's a lot to assume. And if you're in court, you have to prove it. But even if that's all so, what do you do about it now? And what should be done about it now? Huge question. Perhaps the Supreme Court will opine on that in another 7 years. This is my quick thought on it, that kind of behavior, at least the way I described it, if that's proved, should be not allowed. I mean, that companies should not be allowed to make a decision they're going to buy up all of their nascent growing competitors in order to preserve their monopoly. There are actually some good emails that is good for the plaintiffs, good for FTC, that Mark Zuckerberg wrote about how he saw that Instagram was going to be a dynamic threat to him. So I think that the Federal Trade Commission brought a monopolization case rather than a merger case against Facebook for those acquisitions. And I think that ought to make a good Section 2 cause of action. But as I said before, our law is very, very weak, and I'm not sure the FTC will win, but it's a good run. With lots of speculation, I mean, lots of points of fact to be able to be proved, though, before they could win.
I mean, I can jump in here. I don't know if that makes sense, Barbara, but I guess 2 points. First, on the killer acquisition point that both Professor Fox and Cecilia brought up, I think that, you know, again, I'm going to be the economist in here and say there's a flip side to that coin, which is in the tech world, and, you know, I think in many industries, it's really hard to bring these products to market, and particularly in platform businesses, to grow a platform. And so I do think that, you know, some of what is being characterized as killer acquisition, and I'm not saying this is necessarily true across the board, is some of the way that innovation is taking place in these industries from an economic standpoint. And so you're seeing, you know, smaller companies with innovative ideas, bringing those ideas to the market, and an acquisition by a larger company is their exit strategy. It is the way that they're able to get funding and to kind of pursue that idea and introduce that idea to the world. And so again, on this kind of, you know, weariness about these quote unquote killer acquisitions, I think we need to be careful that we don't inadvertently stifle innovation by, you know, kind of regulating them in too strict of a way. On the kind of unringing the bell of kind of already commenced mergers point. A lot of my work at Analysis Group is doing M&A and working with companies to kind of get through the antitrust merger review process. And I think that the merger review process we have now is a very collaborative process between the parties and the agencies, both the DOJ and the FTC, to really kind of get to the heart of any potential competition issues before those lawsuits are brought. And so I think that very collaborative process works really, really well. And it would be I think very difficult to kind of undo that process and or, kind of to figure out a way in which to replicate that process through additional regulation. I think that would be really tricky. I also think, it's really important to do merger review ex post to learn lessons for future mergers. But when we talk about kind of undoing a merger or figuring out a way in which to undo potentially anti-competitive things that have happened as a result of a merger that had been completed that potentially shouldn't have in retrospect, I just think that's a very, very difficult thing to untangle. And we want to be really careful about kind of the unintended consequences that we introduce there and how we think about that. But I think, the process as it is now works for the most part and is very, very collaborative. And there's a lot to be learned by looking at mergers that have been undertaken and kind of figuring out where the potential pitfalls were, where things were overlooked. And I think looking at mergers that were not reviewed and did not face that kind of intense scrutiny and thinking about whether or not they should have and kind of what other thresholds should potentially be put in place to trigger those reviews. But I do think once the merger is completed, you just find yourself in a really, really tricky spot.
Excellent. Thank you so much. And Professor Sokol, I would love to hear your take on this, as I'm especially interested in the point of going back and reviewing past clear transactions and consummated mergers, and sort of what are the implications of that, and what sorts of thresholds might be appropriate for that sort of analysis.
So a lot of my thoughts actually align very closely to what Emily said, particularly what motivates a lot of these deals, why most of these deals are not problematic. For the nascent acquisition hearings that the FTC had back in fall of 2018, I basically said things along those lines. When asked specifically the questions of, does it make sense to do studies? Absolutely. So I actually will go further. This is my radical proposal. Everyone gets at least one. Frankly, everyone should be limited to just one. But here's mine. I actually think that the agencies need to have a quality assurance office. This is not like an ombudsman. This is actually a real quality assurance office, the way every traditional business has a quality assurance office of, are things working? And basically getting people to do an internal review. Are the processes working? And are the outcomes working? They're looking for product defects largely. But this is essentially, if the product is the right decision, we're looking for that product defect. And it's an independent review of agency decision-making. And we see this actually in other organizations. The World Bank, for example, has a quality assurance office. Is it pleasant to have somebody critique your work? No, but we call that tenure and the file that they put together to get tenure. It is highly unpleasant to have somebody sitting on your class and critique your teaching. It is highly unpleasant to have somebody critique line for line every article you've ever written. But you know what? You're better for it. And so I think that ends up being the solution, because a lot of times it is really difficult to go back and unscramble the eggs. And that's actually language that we see, believe it or not, the unscrambling is language we've seen in a number of cases as well. But what it helps us for is the next time around, are we asking the right questions? Because sometimes we didn't even know to ask the right questions. We always, particularly with mergers, we like to always start looking at internal documents. Why? Because when we don't have a lot of good data, it at least gives us a starting point of the kind of questions to ask. Now, sometimes you can have very bad documents, and ultimately you could end up winning in spite of that in front of the agency. Sometimes the agencies will not bring a case, or sometimes they'll lose in court in spite of very bad documents, because it turns out the documents alone are mixed or don't always tell a full story. There are a lot of people that like to brag. I want to go back to the dating apps. Very early on in 2001, the year before I met my wife, I was on such a dating app. And if just one of the 12 things one of the women said was accurate on the dating app, it would have been a great date. But it wasn't, because they constantly fib and puff. And it's not just the internal documents, it's the investment bankers, it's all the third parties who want to get the deal done. So we need to look at more than just that. So what else should we be looking at? Maybe there was certain types of customer data we weren't thinking about. Maybe there was surveys that we didn't undertake. Maybe if we had better data analytic tools in-house, or even knew who to talk to do that kind of analysis group, for example, but others as well, because analysis group also does work for agencies, not just against agencies, it would help. So that's my radical proposal of, I think you're exactly right to be asking these kinds of questions. I don't think we're probing enough after the fact, but it's not as a one-off, it's an institutional failure.
Thank you very, very much. And before Sandhya comes in and gets some of our audience questions in, which, by the way, it does look like our audience members have taken antitrust, I would like to get Cecilia's final opinion. And please, what is your take, Cecilia?
Sure. If I can run with the Tinder example there about, the puffery on Tinder and the fibs and the lies, I think when we think about retroactive looks at these mergers, I think the question is really, after you deal with imperfect information at the beginning, because the agencies are not comprised of psychics, and the agencies do not have perfect data or perfect information into the future. The question is, afterwards, when you're married, can you get a divorce? And it's messy, your assets are tangled. It's going to be not a pleasant process. Everyone is angry. But I think the idea there is that at the time you're trying to decide whether to block the merger, there are error costs at stake, and you don't know, probabilistically whether the harms will materialize. But after, that marriage, after the merger, you have better information. And as long as you're collecting that information, it tells you whether the competitive harms will materialize and whether these concerns that you had thought might have been maybe hypothetical or only a 50% chance of happening can later occur. And when you have information that it does occur, I think it's perfectly reasonable and is why I think Congress wanted to give the agencies the power to do this type of retroactive analysis and to undo mergers that have already been consummated. And I think this is in line with other explanations of why retrospective challenges can help accomplish the goals of antitrust law as a matter of policy. Sometimes exogenous market shocks happen, or something, a new entrant comes and really changes the market that you didn't expect before, and the merger might have made shortages even worse than they would have been absent the merger. And the workability of a remedy, of course, is something that we should consider, and that agencies, I think, will consider in sort of looking at these mergers that have already been consummated. And I think agencies are aware of these types of remedies risks and will try to account for them in deciding to make a challenge. An agency would not take this type of thing lightly. But as Emily said, I think there are, of course, costs to disrupting the finality of the merger process. And there are maybe ways that others have offered, for enforcers to go back and look. I think Manesh Patel at UC Davis had said, that agencies should only challenge a previously reviewed and cleared merger if, the preponderance of the evidence shows the merger has led to substantially lessened competition and there's a reasonable belief by the agencies that the remedy can correct the harm. So I think there are, ideas out there that can help deal with sort of this balance. And I think there are other ways. I think Commissioner Slaughter had proposed, requiring parties in certain vertical mergers to give the FTC ongoing post-clearance data. sufficient for it to take a retrospective analysis. So, you know, if Professor Sokol's quality assessment bureau within the FTC is realized, that could be something that, you know, would be the bread and butter of their work. They could, you know, and that would be one way, I think, to keep the learning going as it should be.
Perfect. Thank you so much to all of our panelists. We do have some time for some audience questions. So why don't we get started? The first one is, how effective do you think it would be for the FTC to bring enforcement actions under Section 5 of the FTC Act? Do you think some of the problematic conduct that doesn't fall under Section 1 or 2 of the Sherman Act could be dealt with under Section 5? So this is an open question. Whoever wants to answer can go for it.
Okay, maybe I'll go for it. Thank you. And it's a very good question. I think there is significant room for the Federal Trade Commission to be bringing cases of in effect, abuse of dominance under Section 5 of the Federal Trade Commission Act. They've been very reluctant to bring these cases under only Section 5 of the Federal Trade Commission Act. They've been incorporating also Section 2 of the Sherman Act and saying this conduct would violate Section 5, but also would violate Section 2 of the Sherman Act. And I think it has been realized, and I think Professor Kovacic was one of the first people who put it out there, that the Sherman Act has shrunk, and because of certain Supreme Court decisions, and there is room for finding conduct anti-competitive that will not meet the standards of Section 2. So this is a really good target for FTC, but FTC needs more powers, and it probably needs to have more powers, including civil remedies, to be granted by Congress.
Perfect. Anyone else? No? Perfect. Then we'll move on to our next question. So given that tech is an ever-changing, evolving thing, how do the FTC and DOJ stay current with those trends via rulemaking? Do they have an innovation department similar to what the CFPB has with new trends in fintech?
So I'll start. A lot of times you have workshops where you bring in industry experts and you do it publicly, and that's helpful. You know, is there a digital group within the FTC? Yes. You know, do I give a lot of credit to the DOJ for having a bunch of staffers, actually including Macon Delrahim himself, who took a data analytics course? Yes. Is this necessarily enough? No. So this is my non-radical suggestion that, again, I said at a different one of the hearings, which is we already have a natural experiment in this case. The agency furthest along is the Competition Markets Authority in the UK. And they actually have a standalone digital unit. Now, my innovation would be to put it within the Economic Analysis Group at DOJ and the Bureau of Economics at the FTC, because these are the people who are really going to focus the most on data analytics, right? And they help in terms of framing, in terms of asking the right questions. And I'll put it this way, the same way that you can't understand how antitrust law functions without at least some very basic knowledge of economic principles, you don't really ask the right economic questions unless you understand the technology. And the technology is going to differ across industries. Biotech, with regard to pharmaceuticals, actually looks different than biotech with regards to devices. There's much more IoT with devices. That's kind of cool. And that gets us back to the digital issue. But oh my God, software and hardware also look different among other industries. And we need to understand all those nuances. And one thing that the CMA has been particularly good at is getting a bunch of people who had worked in tech companies to say, you know what, you had spent time in the Bay Area or somewhere else in the United States. I know you want to be closer to family. This is pre-pandemic time. Why don't you just come work for us? You made a bunch of money. Why don't you come work for the government now for a few years and, you know, bring those insights? And I think that would be incredibly helpful. I don't want as many lifers in this particular agency because it only works if you have people cycling through with the latest understanding of technology.
Emily, did you want to pitch in? You seem like you were agreeing with some of the stuff that Professor Sokol was saying.
I mean, honestly, it's a lot of what we do at Analysis Group is kind of get up to speed on all these different types of technologies and help kind of make these translations. And it's a major undertaking. And so I think there is room, not to plug myself, but to hire consulting firms to try to hire some of this expertise out if the agencies can't make those investments themselves, because I think they're really, really substantive, large investments.
Right, and I would just add too, in thinking about cases, the case teams of attorneys and paralegals and economists do try, to read and keep up with academic literature. It's not just a question of, looking in documents. It's also trying to assess, how does this theory of harm or this potential theory of harm fit into the overall, discussion and the broader academic discussion, the broader economic literature. So I think there's a desire within the division to keep up to date. And we also have a competition policy advocacy section, which, I think they deal with sort of some of the legislative proposals that are out there and sort of keep an eye on those as well. And so I think there are ways in which agencies continue and try to stay agile. I think last year the division also hired a few tech fellows who came in whose main purpose was to work on tech cases. But I think, obviously there's always room to keep learning and to keep staying agile. But I think the agencies, with the resources that they have, try to do as much as they can.
Great. So we have one more question, and it is there a case to be made that we focus on the economic cost of ex-ante regulation simply because they are easier to account for than the cost of ex-post enforcement? And I know that we talked about this a little bit, but just going further, to whom should the inefficiencies or externalities present in each approach accrue?
So I can just start us off to say that really seems like a policy question to me, right? There's just kind of a decision that I don't know who would make it, but kind of where you want to think about these costs accruing. And, obviously there are costs ex ante and ex post. This questioner is exactly right. And I think it's really just a question of, where policymakers decide they want those costs to accrue. But I don't know if others have other ideas on that.
So in a way, one might think of the ex-ante regulation somewhat similar to per se rules in antitrust. That is the sense in which ex-ante regulation is being raised today, that we think we see some conduct that we think is bad and not helpful to innovation and consumers. And if that can be articulated sufficiently well, so that it's not overbroad and that it captures main categories that we're worried about in the big tech firms, it's useful to do that. And the costs are fewer. But then, they're the costs of, you can't really do that kind of articulation that you need without the costs. But, if you can do that, it means that the companies will have more predictability, and they will have the incentive to follow the law, and they will stop doing the very abusive behaviors that are also not good for the market that they are doing and keep doing because the Sherman Act is so weak, it might not catch them for doing them.
Great. Any last thoughts? I think that's all the questions we have for now, but if any other panelists want to say anything or any last remarks, then definitely feel free to.
There was a question about internationalization. I just wanted to say a word about this problem. I think it's a very serious problem. There are these very large tech platforms, and we've separated them out, so maybe it's a handful, They happen to be all American companies. The United States has a system of law that's relatively more laissez-faire than a lot of the rest of the world. And a lot of the rest of the world is doing its own kind of regulation, but country by country by country. This is not the optimal system for controlling, let's say, bad or abusive conduct, if we can know what that is, of big tech. And so all things being equal, one might say it would be really better to have a common understanding in the world. And yet it's very hard to get this common understanding because the various countries and jurisdictions have very different senses of the right amount of intervention. So we go along with national systems that have a lot of costs because they're not integrated. And we just accept it as it is because there doesn't seem to be an international way out. But we keep trying to have more convergence through institutions like International Competition Network, and we should keep trying. But it's a puzzle and a paradox.
I have just one very quick closing thought. For those of you who are still students, this is an amazing time to get involved in the field. It is not often where I say the very foundations of which a body of law assumes to be correct are literally being shaken up right now. Whether or not it actually leads to something, who knows? But certainly for the first time in a generation, the future is not clear. I don't mean in a particular merger. I mean, as a field, it is not clear. And that's always a very exciting time to join a field when it is in disruption. It doesn't mean that it's not a stressful time. It is. But what it also means is it is intellectually rewarding. And on some level, if you're going to have a job, it should be a job, not a jail. And as a result, you should be excited to go to work every day, sometimes weary and battle fatigued, but at least excited and feel passionate about it. No one wakes up and says, I want to do reinsurance, but I think there are a bunch of people that wake up and say, I want to do antitrust economics. I want to do antitrust law. I want to just focus on the policy side. That's exciting. Follow your passions.
That's a great pitch too for any student out there who's interested in joining DOJ Antitrust. Feel free to send me an email. I'm happy to chat with you about it. I know you're probably thinking of lots of options after school, but I really like working at the division, and I think it's a great place for anyone who is interested in sort of the intellectual questions about antitrust.
I'll just say
it's a great time. There's so much intellectual excitement, and thank our sponsors, Sandhya and Barbara, for putting this together. It really is a very exciting panel, and we hope that students in the audience are excited to participate in this great endeavor of antitrust.
Perfect. That was such a great way to end our conference. Thank you so much for all the panelists for coming, and to all of our attendees for coming here and asking your questions and participating. If you have any follow-up questions, we ask you to reach out to the Antitrust Association or DW Business and Finance Conference, which put all of this together. And I would like to also thank our conference organizers, Abraham, Professor Sala, and Professor Pam, and our other antitrust panel organizers, Alejandra and Alejandro. Thank you once again for joining our panel and for attending the conference. In about a few minutes, we'll have closing remarks, so we ask you to stick around.